The video's running? All right. Bushy eyebrows, I think, is next. This is a defense motion.
DM is considered an eyewitness, and eyewitness testimony is some of, if not the most impactful testimony in a trial. The testimony must be subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second. Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a photo lineup and there wasn't a show up, or the court considers the science behind memory, the criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony. Between Manson-Biggers and the science of memory, there are several factors that are consistently considered, and I'm going to go through a few of those. Factor one, what was the opportunity to see? This is also known as first phase of development of memory or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit, and the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing. We submitted 2 pictures as our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk, and given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that she saw a person wearing all black, not insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about eyebrows was law enforcement. In her second interview, Detective Mowry asked her if she saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows. That's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again, she doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty. This supports unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about is impacted by emotion and stress. In this case, that is an important consideration. Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion under this definition of confabulation is Detective Mowry asking her about eyebrows and each law enforcement officer, then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained what one was and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps. This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information, exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So the DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Kohberger to say, this is the person she identified. DM told police that she looked at Mr. Kohberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Kohberger's photo shows bushy eyebrows. That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo through her testimony off of his phone, if they make the argument in an opening statement that that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them. But that is not the way law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
The defendant relies on the Manson-Biggers test. We just went through the 5-factor balancing test for their argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions before Bryan Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, toned build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Kohberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, "Mr. Kohberger does not have bushy eyebrows, but the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent." So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce, they're correct, we would not introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly. Thank you.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about how important this testimony is, and that's why this court must analyze the reliability going through all of the factors that I expressed. And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. Well, I'll take that issue under advisement. Text message, pardon me, 911 call.
Judge, the state seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911. Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event, and two, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript, if the court would like it. Thank you.
Well, I may ask you some more questions because it seemed to me from the briefs that the defense focused in on three particular parts of the 911 call as not falling within the exceptions. So he didn't address those specifically, but let me see where the defense is at.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving me text stuff?
We are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen, and then the 8 hours pass, and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. and he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs, and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, if you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 in the morning, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram, she was on Snapchat, she was on Indeed, she was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statement she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So I would ask the court to exclude the 911 call.
Judge, I think there's a misapplication of the rule as well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 in the morning when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes, a period of time elapses. She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at this point, she decides to call over friends to come and check on the residents, remembering what happened the night before. Now adding to that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Santa, and then instructs them something is wrong, and to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What do I do, or what's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates, or one of the roommates passed out and was drunk last night, and she's not waking up. She didn't witness anything.
Well, I think that falls under her present sense impression of what is happening at that time.
Her hearsay statement of what somebody else told her.
That's
She's
true.
not experiencing anything in that sense, other than being there. And I think the case of, look at my note here, of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call. But we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
I mean, it's not offered for the truth. You better have a good answer about what the reason is other than the truth, and I'm not hearing one.
Only that it's part of the substance of the entire 911 call, and that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
That's why I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. It's unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the defense first plays the tape, and parts are hearsay are left out, and you want to complete it, you can. But you don't get to complete with hearsay your own offered conversation, or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine, which I'm not sure you get to rely upon. Well, I know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
I think that's fair. I mean, we only have certain exceptions to the rule. I still believe that the entire call in its entirety, and under the circumstances that the call was made, the entire call could be considered an excited utterances by all declarants.
Also, there's a statement by EA, and they saw some man in their house last night. Yeah. That seems to me to even be more removed. Again, it's a statement of a hearsay of somebody else, so you got hearsay within hearsay, and not by somebody who observed that and relating to the event that happened previously.
That's true.
So what non-truth purposes is that statement?
Again, I would just have to say that the whole
Because
call is
that seems to
excited.
me to be even more concerning,
Right.
right? The first one, I mean, my roommates aren't waking up, and we're gonna have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still,
Concern about being an offer for the truth is even greater there.
right, and the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call. And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously, a lot of emotion in their voice, considering what's going on. It's not always clear to understand what's being said, so I think a transcript is a fair way also to convey this and should be allowed with the audio. Nothing further from the state.
Transcript and testimony. In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact that certified doesn't make it otherwise independently admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that it could be self-authenticating. It has sufficient standards of reliability built into the transcript.
That may be one. 24 might be a hook. You haven't complied with the requirements of 24 at this point, but
No, but we haven't met our exhibit or witness deadline yet. So obviously, we would have to lay the proper foundation for that and would intend to do so. Thank you.
all right, I think I need to take a statement by statement approach to this. Do you think that the surviving roommates, surviving victims of the burglary were under the stress of the immediate events, but there are some questions about some of the other statements in there as to whether they would come in. So I think, in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them, as I've outlined in my questions. But I will write that because to give you more particular guidance. All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state, asking to bring in the phone records for DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply, and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion doctrine. If it's necessary to explain the prior admitted stuff and it's close enough connection in time and subject matter, and so there's some questions there, it's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls. And those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after, so for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff, talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that
That
morning.
wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards. Those are after they retreated to the room together and, and what happened there.
Mostly I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Before
There-
anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that, when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means an out-of-court statement. Then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance, and then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that, 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
All right, next item is the demonstrative evidence.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly, we can use diagrams and floor plans, which we did at the grand jury. But it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each floor, where the bedrooms are, how the first
Well, for
floors.
it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. The concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this three-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a 2-scale model. And the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly, but as we revisited, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they were to take a flip pad and try to draw things, to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses in explaining to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a 2-scale exhibit, and the defense is welcome to offer their 3D imaging or whatever it is that they want to, if they want to have a 2-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury. When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
And I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid. I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there, it's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
Your Honor, we request that you exclude the state from using this dollhouse model. As is everything we're talking about here today, we're talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials, they didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Demonstrative exhibits and trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court, I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You had access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
Absolutely, we did. What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway's just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Kohberger. To have this come in and have the jury look at this, it's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it. A demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the way the house really existed that night. And the jury can place great weight on that. And it might not be actual. It could skew the testimony. It could skew the truth. And that's really important in this case.
Where cross-examination comes in?
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know anything about?
You had access to the house and you know what the house looked like and you have photographs.
I do have those things, but if there's a slight shift in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look at this, to try to get our expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law that talks about demonstrative exhibits, you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury. When you're looking at the Masters case, it's an exact car seat. That was a civil case. It's an exact car seat, like was in the case at bar at that time. Here, this demonstrative exhibit that's going to be large may or may not be accurate. Conversely, I have the photographs, so does the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the defense. With all of the thousands of photographs and all of the people that have been through the house, There's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to you. To allow them to rename this is a violation of Mr. Kohberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Kohberger we have done everything we can to be apprised of what the state's going to do. And at the last minute to pull this out after we've asked in discovery for this and to label it a demonstrative exhibit, Your Honor, that just can't happen if Mr. Kohberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this be excluded.
The 3D, or in the, I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
You have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows it, that's what we have to do. But the court should be well aware that when the state does these kinds of things, these things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens. We have to work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute outside of the deadline set by the court and outside of the rules further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
Your Honor, what Ms. Taylor is talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of the underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested it. In our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not what happened. We provided the information we received. As soon as we received it, it was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
thank you. I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. And the more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR modeling measurements, whatever that was done by the FBI. It's April. Trial is starts in August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial, and will not go to the jury. Jury will not have it in its presence when it deliberates. I don't see, frankly, the concern with respect to the use of a model in a case like this. So I'm going to allow it. The state will make it available to the defense prior to the pretrial conference and sooner if it doesn't sound like it's complete yet, but as soon as it's done and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel. If there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So. All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement, and a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. I add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights. And they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the ability, the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration, now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson, his pleadings with the court, his briefing. have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 4, whatever it was,
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir.
or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
All right, let's talk about the AT&T stuff.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window, so there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're
So
talking.
you're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right. I have nothing further, thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back
Or
door.
from AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that,
It's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That,
For the 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
you would
which,
agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from
You're,
people that I've worked
you're giving
with.
me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because
records.
they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay? So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What you're
them.
talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. but the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my
Our
attention more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do, and that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available And I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it, but you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts, and so I wanted to provide that to the
So
court.
I did see that and read it.
Okay, good, thank you. Let me get to my same page. I want to start, though, today with my presentation and my request with a little bit of history with this case, and as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence, and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16, and so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence, and I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Marin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, Agent Balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry.
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't, and we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done, and to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage, and then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as the disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative,
That's just impeachment.
well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that. And I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes, you missed that. And what could that mean? Couldn't it mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more, too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I agree, and when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. they have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said, your job's not done, I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in, bits at a time. And that is just not the way the system works, and that's in violation of Mr. Kohberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position, and that's the way to bring it back and keep the burden at the table it should be, and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information?
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit, or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is
dictated
that
it.
Were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it, and let me tell you what I mean.
Talk about the adversarial part. I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time, I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
I recall the 47 said it was traveling southwest.
Well, that's what we say. That's what the
affidavit-
record
that's what the-
shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later indicates it was traveling southwest of Pullman.
None of the search warrant affidavits have anything about 2:54. It was,
I understand that. My point is, the time was wrong, but the point, the direction of travel is the same.
there are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So and I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying, that's what they haven't done.
That's not what they've done, Your Honor. And
That's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them, and we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the
That's not an opinion, first of all. It is an explanation of why they didn't submit evidence to CODIS. I'm not seeing how that's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy, here's when we submit stuff to CODIS, and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
So the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is, I don't really view that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person.
right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology, and we are,
Didn't you produce an expert who said that, that there wasn't, it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
That
doesn't,
Dawson testimony about the degree of intoxication goes to the, what I'm assuming was given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway, so this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. Most of the rest, there were three, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed in that. The last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk.
Through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
If he can say all of those things, I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is this, I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us, And what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event, and to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules, it's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now. And we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts.
Defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over-disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this. And in fact, in that stipulation to allow them more time to disclose, we stated, it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
If we were talking about one expert of the state's, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied, so we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I want to, I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if there's, what is given is adequate. If there are concerns. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing, continual supplementation and disclosure, and so I wanted to accommodate that within the time frame, within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion. All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There may
talk.
be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're
were.
not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about. but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like, and so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology, it has to do with machine learning. And I think a lot of this is something that
AI.
Pardon?
Isn't that AI, machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration. And if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon. Because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
Well, you got what they got, right?
not really, because what we have is, we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that Mr. Kohberger, or at least his name, purchased the knife sheath and cleaning thing, knife sharpening, equipment, and looked as anybody who orders on Amazon does. Is it Where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we
Would
would
it ever
take.
be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I
What
guess.
basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him and then, and that there's
More than
somehow
a purchase in
intent.
a household account, it's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, you know, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading, given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, you know, that based on the information that you understand, that equates to a purchase. And I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase, when there's a lot more to that.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
No, that is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply in an argument, they will apply intent to purchase a K-bar to get to November
It's an
13th,
inference that you can draw from
2022.
the evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness, and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence.
Well,
If everybody would just disclose, we wouldn't be having this
But
back and
I think
forth,
the problem is you view it as a more complex issue than the state does.
because it is.
Well, that's not their worldview.
okay? And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not gonna have opinions. They review records, they're gonna testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's gonna testify to. And what he's gonna say, he's very careful in what he says that he's gonna say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.
All right, we are now at the state's motion regarding neuropsychological and psychiatric evidence, as well as then closely followed by the defense's motion with respect to autism spectrum disorder.
Thank you, Your Honor. I hate to sound like a broken record, but once again, this seems to be a developing issue. The basis for our motion when we first filed it was in response to the defendant's supplemental responses on experts, the declarations of Dr. Orr and Dr. Ryan. Each of those talk about mental condition. And each of their disclosures, right on the first page, said that this evidence is not intended as mental element defenses under 18-207. So our response was, well, then it's not admissible. It's just very simple. The statute covers that. What happened after that is that it morphed now into a new position from the defendant that there are neurobiological and physical conditions that are come into play. Not to the exclusion of the mental conditions that were alleged before, but Dr. Lewin talks about the physical conditions are predominant as opposed to exclusive. So that kind of brings us to where we are for the issues for today, and I'll try to be as succinct as I can. The first issue, what was initially raised by the defense, is they expressed concern about how the defendant's demeanor is going to present to the jury as the defendant is just sitting in the courtroom at counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably like he's not involved or something in a negative fashion. The defendant cites no authority for this, and indeed, I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. But there's just simply no basis for that, and we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited to the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability or right to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence.
or giving us direction to specifically go get information. But I don't want my representation to you as a non-expert, as a lawyer making this argument. I'm not qualified to tell you what's going on with his exact dexterity issues. He has fine motor skill issues. He presents odd physically, and it is a different presentation with what he's got than someone who might be sitting in a courtroom, perhaps with missing a hand, for example. Another significant issue that is impacted by his ASD is his decision and ability to testify. The Burr case is instructive because part of the basis for the reversal was that Mr. Burr was encouraged not to testify out of fear of how his autism would come across to the jury. Because of his ASD, because of Mr. Kohberger's ASD, decision-making is already very difficult for him. If we cannot let the jury know about Mr. Kohberger's autism, the decision about his testifying will be nearly impossible for him and for us as we guide him. We need to avoid misperceptions of the jurors, and the only way to do that is to inform them. The cases I have referenced discuss how the constitutional right to due process is violated when a jury does not get to take into consideration this specific type of evidence. There's one other way that I want you to think about this, one other frame of mind. Imagine if you do not let this testimony in phase 1 of the trial, and the jury convicts Mr. Kohberger. How angry and misled might those jurors feel when they learn in mitigation, where without a doubt this comes in at mitigation, that he has this disorder and it has them second guessing themselves. We must avoid that possibility. We ask for an order to allow its admission. We are not asking for carte blanche ability to lay all of that out in opening statement. This is something where we have no problem, where we take a step-by-step approach, but we've got to be able to tell the jury in opening statement that he has ASD. Thank you.
So what we've just heard from the defendant still begs the question of what's relevant and irrelevant in Idaho. And I think the case law is clear to the extent there is case law that the defendant's appearance when he's not on the stand is not relevant. I think that the court, if it has concerns about that, could add language to the EvilleCJ 202 that talks about the type of evidence the jury can consider, to say the jury may not consider the defendant's demeanor as he is seated in the courtroom, if the court feels that's appropriate. I'm not sure it's necessary because 202 specifically lists what jurors can consider, and the defendant's demeanor is not part of that. In response to Your Honor's question about, or observation that there's no evidence from an expert here that the defendant is incapable of committing these crimes, the response from the defendant was, well, yeah, that's right, which is exactly our concern, because the defendant in his filings took what little was in the expert disclosures and then stretched it out to this conclusion that the defendant is incapable of committing the crimes when the experts don't say that. I mean, they are essentially creating an opinion that doesn't exist. So, Your Honor, our request stands. Certainly the evidence that's being proffered about his demeanor is not relevant. It shouldn't be admitted. And if there's an issue that comes up about the defendant on the stand and his appearance there, I think we can address that as it comes up. Likewise, if the state opens the door to questions about the defendant's behaviors, which we are not intending to do, we can address the issue at that time. So we'd ask the court to defer any kind of ruling on those hypothetical situations. Thank you, sir.
You know, if we didn't have 2.5 years of media coverage to know how Mr. Kohberger's physical presence has been perceived, the state might have a little bit more credibility with that argument that it's not relevant. But we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes, and it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is his autism spectrum, what you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. Because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and stories with experts doing body language studying about him, including the fact that this is how he holds his hands, and there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance. That is exactly what jurors are doing. They're judging the evidence. They're staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad. And he is not capable of doing that through no fault of his own. And there is, I just explained to you that there are studies that have been done and there's case law on this, that it's important that the jury be informed.
There's also a case law that says that none of what happens except in the testimony is relevant. So how do I square those two things? In other
Because
words, I give the jury an instruction that specifically says, don't judge this case based on anything except that you hear on that witness stand. And then if I do this, what you're asking me to do, I'm basically telling them, but that's okay.
the state's asking you to give a jury instruction that says that. We're asking
Part of
you
the
to let us
standard
put
instruction- Part
put
of the standard
testimony on.
instruction is that the jury may not consider as evidence anything other than the testimony and exhibits admitted in the trial.
Judge, I just quoted cases to you where we don't get to live in a state of denial, right? We can pretend, but that's not what exists in society.
I
So
have to
we
live
don't
in
get
a
to live
state
in a
of
state
what
of
the law
denial.
is my concern.
Pardon?
I have to live in a state with what the current state of the law is
And
in
I just,
Idaho.
well, I just gave you
You
examples.
gave me no Idaho cases.
But Judge, you can have the courage to be the first one to set it right here then, because autism spectrum disorder is very real in our society. 1 in 59 people have it, 4 times more common in males.
I'm not in any way trying to downplay those that may be diagnosed on the spectrum. I'm trying to figure out how do I do this where I have settled legal precedent that I'm supposed to follow that says the jury may not consider as evidence anything other than the testimony at the witness stand. They can't consider, they're not supposed to consider the demeanor of the witness. Now, I will say, having seen Mr. Kohberger over numerous days now, I haven't seen anything unusual in terms of his demeanor. But, I'm not, scrutinizing him on YouTube the way maybe others are. But I understand your concern, and I'm not trying to downplay it. I'm just trying to understand how I get there in light of the legal requirements that I'm supposed to tell the jury, don't consider any of that. Maybe the way is to say, the way the parties appear, what happens at counsel table is not evidence. You shouldn't be concerned about it, and it should play no role in your decision. Would that do it?
Judge, the proper way to do this is through testimony. I just went through a litany of cases where that's what the courts have said in other states is the way
haven't
to
read this,
handle it.
I don't think those cases were those cited to it? the court?
They're not Idaho cases, no. But then it's an issue of first impression here, right? And so you get to make the decision, and you can get it right. You can allow the testimony, right? I mean, if it's an issue of first impression and you're looking for guidance around the United States, then do what other states are doing. That's the solution, not a jury instruction.
I'll take the matter under advisement. The council cited cases that weren't cited in the briefing, so I'll need to look at those. All right, let's talk about the motions to strike the death penalty regarding the same issue.
All right, focusing now to a different phase of the trial and why this should be a grounds to not even let Mr. Kohberger be considered for death. There's too great a risk that constitutionally protected mitigation can be reliably assessed by a jury. The impairments cited by the United States Supreme Court in holding that the death penalty is unconstitutionally reliable for juveniles and people with intellectual disability apply with equal force to people with ASD, and specifically to Mr. Kohberger given his deficits. Courts are expected to apply general legal principles from Supreme Court precedent to new facts. The United States Supreme Court just reiterated this in Andrew versus White, a 2025 decision decided January 21st, 2025. The general legal principle here is that the Eighth Amendment and its requirement of heightened reliability in capital sentencing applies. Unreliability exists when a defendant has an inability to present mitigation evidence, which creates a unacceptable risk of wrongful execution. The four impairments in Atkins, which apply here, are A, less able to give meaningful assistance to their counsel, B, demeanor may create an unwarranted impression of lack of remorse for their crimes, C, typically poor witnesses, and D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All four of these impairments apply to ASD generally and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions. He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his fives upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed. And bring that to current time where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give tremendous weight to perceived remorse or the lack thereof. So again, I'm talking about not phase 1, but if we get to phase 2, this perceived remorse and their decision about the death penalty. As evidenced, as I've explained, by the media demonizing his appearance. As a poor witness, he has difficult picking up on nonverbal cues. Tone and cadence are abnormal. Affect is stiff, and language is disorganized, repetitive, and oddly formal. He really struggles with making decisions, such as, like I expressed, the decision to testify. He needs instructions repeated to him. He's easily distracted on what is happening around him or so focused that he's lost in the big picture. He perseverates on unimportant details, and these are symptoms of his disability that will either unfairly keep him from testifying on his own behalf or alienate him from a jury and make him easily trapped on cross-examination. And the double-edged sword applies as well, because the stoic affect and incongruent facial expressions may be seen as a lack of remorse, an inability to react to emotional moments that call for emotion, which is often an aggravating factor for juries. Studies in our motion related to striking the death on page 22 to 23 cited the bias towards people with ASD. Again, the media coverage has repeatedly described him as soulless and evil. I want to address the issue of national consensus because the state pointed that out. First of all, the national consensus standard is not something that is required if you make an unreliability finding. But even if you determine that a national consensus is required, there is one because of the factors analyzed, in Atkins all apply to ASD as a class of person that society wants to protect. They are the same vulnerabilities. ASD individuals like Mr. Kohberger are labeled protected handicap students, below basic academically, unique thinking and reasoning make intellectual function difficult to summarize, poor fine motor skills, not comfortable speaking or overly verbose, can't make eye contact, require repeated instructions. Those were all specific statements in his school records. The Supreme Court has not established a clear,
Doctoral program?
pardon?
Is that before his doctoral program? In terms of his academics?
Yeah, the school records that I'm reporting here were definitely for him as a small child, but I wouldn't say that that there weren't issues that were derived as when he was in undergraduate or his master's degree program. And the other thing that's important is that it's really inappropriate based on what the experts say to put more weight on someone's IQ and less weight and make that IQ overcome adaptive function issues. The Supreme Court has not established a clear methodology for determining when a national consensus exists. The court has looked at state legislators, but also medical and psychological research, international standards, and there is an rapidly increasing awareness of ASD across society, including in the legal system, as outlined in our briefing. As a society, there is a consensus to protect this class of persons. And if you don't agree that any of those arguments are convincing, then some court needs to have the courage to be the first to declare a consensus, and that should be you. Thank you.
Your Honor, I want to start with the Atkins decision because the U.S. Supreme Court are the experts that this court is bound by. And that court specifically found in Atkins that there were two reasons why the individuals they were contemplating could not be subject to death. And it was sub-average intellectual functioning plus significant limitation in adaptive skills. What the defense is asking is to eliminate that first critical component and look only at adaptive skills. And the defendant's not the first to try that. In Idaho, the Idaho Supreme Court has rejected that argument in Dunlap. Now, it wasn't about ASD, but the argument was the same, that mental illness has some of the same conditions that were talked about in Atkins, and therefore the Eighth Amendment prohibits execution. I would note that the Idaho Supreme Court did not even entertain that argument sufficiently to do a symptom by symptom comparison between the mentally ill and those who were found to be intellectually disabled in Atkins. Instead, the court cited, by my count, 10 other courts that had rejected similar arguments and said, we agree with them. I don't know how you can read Dunlap in any other way than the Idaho Supreme Court has said it does not violate the Eighth Amendment unless and until the U.S. Supreme Court extends it. And they haven't done that, and they still haven't done that. Now, on the national consensus issue, national consensus is a critical part of an evolving standards of decency claim. It's at the very heart of that claim. That's what it means. An evolving standard of decency requires some kind of national consensus. And the critical place you look for that are the actions of state legislatures. Not a single state has said that someone with ASD cannot be executed. They cited to 2 states in their brief to support their claim. Neither of them have laws that preclude this. In fact, their laws, both passed within the last 5 years, did add to the list certain mental illnesses, but they did not add ASD. That means those legislatures considered which mental illnesses should we add to this list and rejected the idea of adding ASD. So that's not the national consensus that the defendant would need for this type of claim. Based on Dunlap and the plain language of Atkins and the complete lack of any kind of national consensus, we would ask this court to deny the motion. Thank you.
I addressed the issue of national consensus initially, so I'm not going to repeat why that is something that you don't need to find. But I do want to point you to another resource that is really informative, because what we're asking is that you make this finding on the unreliability principle. And Scott Sunby has an article titled "The True Legacy of Atkins and Roper, the Unreliable Principle and the Unraveling of the Death Penalty." And that explains the court's pathway on how Atkins and Roper is focused really on why society protects people with vulnerabilities, and why people with vulnerabilities like ASD cannot properly be reliably mitigated in front of a capital qualified jury. And that's why you should strike the death penalty in this case. Thank you.
Thank you. I'll take the matter under advisement and issue a written opinion. Let's address what I have as to be the last item, which is the motion to strike the death penalty regarding discovery.
Your Honor, we are asking the court to strike the death penalty as well as issue some additional rulings in this case as it relates to the discovery issues. Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet It's constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery. There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music, how much of that is video and movies off personal devices, how much of that is things that no reason to look at.
well, the problem is, Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things, and rather waiting to tie it to the death penalty at the end?
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes. And the first question I asked you was, have you looked at it? And you said no. You hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery.
Well, I'm here to tell you now that we haven't reviewed all of the discovery. Over the course of the case, there have been multiple emails and letters back and forth with counsel about discovery. We've had motions to compel discovery. When I first met you, I was very candid with you about the size of discovery and that our team had not looked at it all. Since that time, we've continued to receive additional discovery. And probably most importantly, that brings us to now, why now? I think that's a fair question. Since we began with the expert disclosures, and I'm not going to go all the way back through that, I talked about that exhaustively, but that was a real turning point for us, that when you're moving along with a schedule and a pace, in this case, especially with the sizable amount of discovery, and I want to tell you what's in there in just a second too, but we're moving along at a specific pace, and the expert disclosures, we've talked a lot about that, and those were not adequate. The court told the state to do a better job. We've talked exhaustively about that, but that disrupts the flow of everything that we're doing when that happens. We had worked diligently to get motions filed and to get our other motions that were being heard in January prepared and to meet our expert disclosure. And now in the time since January 24th, we've had repeated meetings with experts with new information here to find out what it means, new information there to find out what it means. And it just hasn't allowed for enough time to focus on the discovery. And that's not all. We have these motions in limine. We've talked quite a bit about the dollhouse and the issues with the dollhouse. That takes time. Everything like that takes chunks of our time. We don't have all the discovery reviewed. That discovery consists of thousands and thousands and thousands of pages of police reports. I know the court has a little bit of a glimpse of that. The court asked the state to give them Detective Mowry's police reports that he authored. I think it took him 10 days to get them all gathered up to the court. That's one officer. That's just one officer. We have, I think, over 15,000 photographs.
4 years in the fall,
No,
the homicide?
no. It's 3 years in the fall since the homicide. Mr. Kohberger was arrested.
Fall of 26 is what I was referring to. So 3.5 years.
The homicides happened in 2022, November. So
2026
we are
November.
2.5 years since that happened. We're in 2025. Would be 3 years in November of 2025.
Happened in November of 2022. Oh, you're right. Never mind.
It's been a long day, Your Honor.
It's been a long day. I'm off by a year, and I feel a lot older than that, than having aged more than just a year in this hearing, but regardless, at what point are you ready? Does that mean that in no case where there's a lot of data, can we have the death penalty?
Your Honor, that,
Took on a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already. And then things have happened since that point in time in this case that have set us back.
The skeptic would look at this and say, well, this is what Judge Boyce did when there was a last-minute discovery issue. This isn't a last-minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
I'd ask you to look at the things that have happened since our, I would say our status conference, the first time we met, when I was hopeful that we could get through a number of the things that we still had left to do. There are things that have occurred that have taken an extraordinary amount of time. There are a lot of things that we haven't had a chance to look at yet. We continue to go through discovery as rapidly as we can. We're just not going to get through all of it by the time we get to trial. Part of that is the way that it's organized, and that's why part of our request is to have the state give us the documents they rely on. And
With giving hot documents is if they don't point out a document that you later say, oh, we should have known about that one. Now somehow they're culpable for not seeing the document the same way you did. And so that's why courts are very hesitant to employ that remedy, because it makes the state kind of do your job for you.
Your Honor, I would let the court know how we've received discovery in this case. And this has been a topic between counsel since the initiation of the case. The discovery goes to the police department, and then sometime later, the state gets it, and then they get it to us. So there's a delay already, but the documents don't come in any organized fashion. When you received all of Detective Mowry's police reports, those would have been scattered over probably a year for us to get. We litigated the video, 1112 King video. We litigated that for about a year before we got the full copy of that. Those are all things that take time, and we are now months before trial with the cumulative effect of what's happened. And we now are faced with the issues with expert disclosures. Hearing the state today, I don't expect they're done trickling in expert disclosure after expert disclosure. At what point is it enough when we can be counting on that's it, we can get ready? The court's discovery deadline came and went. A lot of additional discovery has come past that deadline. At what point is that enough? I'm picking up more discovery today if I can meet up with the prosecutor.
Is it a penalty-based discovery?
I don't know. I haven't seen it yet.
That's part of my problem is I don't know, because you're very vague about what it is you haven't been able to do.
Well, let me tell you then. There is surveillance video from all of the university, all of U of I, and there's probably some pretty critical places where that discovery or where that video exists. I haven't watched that. I've sat down to watch it on several different occasions, and other team members have sat down to watch parts of it too, to try to see what's there. The way we've received it, it's not labeled in any fashion at all. I can open up a folder and I can look at something and figure out what date and time that's from. And there's multiple cameras and multiple days. There's no index, there's no guide to what it is. So I haven't looked at all of that. There's a couple of additional video footages that I haven't looked at. Now, if we want to start talking about cell phone data and third-party digital data, I have an expert who said it would take 3 years for him, an expert who knows how to do this, to go through every single piece of that. Now, he's been through a lot because we've had a little bit over 2 years to work on that. Not a full 2 years because we haven't had that discovery for the full 2 years. But there's quite a bit that I haven't looked at. I don't have an expert giving me even a report. We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip, just in trying to work through some of these issues, we came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know. We were disclosed a bunch of email communication between different law enforcement officers, different lab personnel. I probably have read about half of those by now, and different parts of our team have read different parts of it, but we don't have it completed yet. Those are some quick examples that I can give you. I've looked at every picture, and I believe I've read every police report. There's a lot left to do that could have things that are favorable to Mr. Kohberger. In January, I had to stop doing that because I had to start worrying about the expert disclosures that we didn't get. I continued that through February. We've responded to the motions in limine. We've responded to the dollhouse. We've met our deadline with our mitigation experts. We're meeting the deadlines that are set out, but there's only 24 hours in a day. This is what's happened here is not satisfactory. That the discovery is not in an organized fashion. It's not in a searchable fashion. We've encountered documents that have been locked, most critically the entire DeSales record for Mr. Kohberger's education at the DeSales University. Those were locked documents. They were a complete mess. It took one of our team members probably 10 days to get them in an organized fashion where we could understand what document went with what other type of classroom or assignment or other event. I will tell you about the motion in limine we didn't discuss today, the self-authenticating records. When we received the state's initial list, these are the list of things that we want to put in with a certificate. We went through those discovery folders, and those didn't contain just one document. They didn't even contain a document that made sense about what the state was trying to do. That took me personally about 10 hours to go through all of those folders of discovery so that I could write a response to that. The state replied, abandoning wanting to use about half of those right out of the gate after I'd spent the 10 hours. And we come today prepared that the court was 100% right. Those pleadings weren't ready. There's not a packet with a certificate of authenticity for the court to make a decision on. The court was right. But that doesn't mean that I can't be prepared. Those things take time. And when we're talking about the amount of discovery that's left outstanding, everything that happens like that eats up those minutes. In this situation, Your Honor, it's not that we saw what Judge Boyce did in Vallow and thought this is a great idea. We are at the end of our rope doing everything we can. And I know about what Judge Boyce did. And I have to come to you and say, you need to do this too. This impacts Mr. Kohberger. I can't not bring this motion because somebody might think I was waiting to the last minute. I can tell you we weren't. We weren't. We've been working as diligently as we possibly can work on this case. We have understood the court's.
Have you gone to Judge Monson to ask for additional resources?
Well, Your Honor, we do have an additional resource. We recently added our attorney, Ms. Barlow, to.
A team of another 5 or 6 paralegals, for example, to go through stuff.
I can definitely do that. I don't know how that puts the information in my head fast enough, but I can definitely do
Point
that.
of having litigated many very large cases, you have staff that tell you, here's an important document. And then that one comes to your attention from the, as you pointed out, the gigabyte or terabytes of probably pointless video cameras that nobody's ever going to rely on, that don't show a thing.
If I'd had a team of 5 more paralegals that understood the case already, that would be one thing. I certainly can ask Judge Monson for additional resources. I certainly can try to get somebody to understand what the issues are. I don't have a problem doing that, but that doesn't change where we are now. That doesn't change the things that have come up that have impacted our ability to prepare. I understand that the court has said this is the trial date, it's carved in stone. And I've done my best to adhere to it, and I'm here now saying that the death penalty needs to be struck so that there's fairness to Mr. Kohberger. The remedies for the court are to strike the death penalty and to have the state give us a list of Brady documents and the documents that they want to rely on. This is a huge amount of discovery, and we don't have the same resources of the state.
I'm going to get a list of the documents here in terms of exhibits in the next few days, I would imagine. I'm not sure. April what is that date?
Well, it's just a little over a week away. Ours are due the same day.
Well, but if there's things on there that you didn't anticipate. This is a process where there's the ability to add things by your part if there's things that you didn't add, if you discover something else in there. But the point is, you will know generally the universe of documents that the state's going to rely on in 2 weeks.
I will know those. I will know those. And when I produce mine, the state will know what I can rely on, but I don't know what I don't know yet.
It sounds like you would never know what you don't know, given what you've told me. It's going to take, 18 billion years to get through.
Well, I don't think it'll take 18 billion years, Your Honor. I think that,
Well, it was several decades, as I recall, is what you'd said, or several hundred years.
I can promise you I won't take several hundred years, but I,
You see my point? That's what you said it would take to get through that, like, an individual. I have a hard time taking that at face value because that's not a realistic answer.
my realistic answer, Your Honor, is that we were working, and we still are working diligently, but the discovery was one of the biggest things that we were doing methodically, going through that discovery so that we could understand everything that the state had given us, even in its disorganized fashion. And that changed with the things that have come up over the last few months. Our entire plan, our schedule has changed to be responsive to everything else. And that's not Mr. Kohberger's fault.
For complex litigation generally, when you're in the expert phase, I mean, that's not unusual.
I guess, Your Honor, I think it's unusual when deadlines are blown by the state or not adhered to by the state, and our client pays the price for that. So I do think it's unusual. I think it's unusual to receive discovery where you might get 23 pages of a transcript, and then 4 weeks later, you get the rest of that transcript. We have had to match up discovery every step of the way. I don't think that's usual. I think there are things that have occurred in the path of discovery that are not usual at all, and I think things that have happened.
I guess my point is if the discovery is being provided in that way, this is something I should have heard about in September.
I advised the court that we were not
That you had not yet gotten through things,
I-
but you didn't advise the pattern of the way you're getting discovery in terms of, incomplete here and incomplete there, et cetera. That's all new.
I agree that that's new to Your Honor. I know that we discussed a sizable amount of recent discovery we had gotten. Those issues came up prior to this court taking the case over. We had talked about the way discovery was being received early on in the case. We filed discovery request after discovery request in addition to talking about the mismatched way discovery was received. That has been put on the record. My hope was with the state's discovery deadline, with that cutoff date, that we'd be able to pull it together. My hope has been that until these new things have happened to shift us off the course that we were on. And I'm here to tell you about it today. I think it would be a lot worse if I stood up at jury trial and you said, "Is the defense ready?" And I said, "No, we haven't read all the discovery." So this is my
Right,
opportunity.
that would make me happy.
Well, this is my opportunity to let you know. We filed this motion several weeks ago, so the prosecutor and the court's been advised. We have been diligently trying to get through it all. We can't. It wouldn't matter if I had 10 more people right now, given the shortness of time with that. but I know that there are remedies the court can take. I understand I'm going to get their exhibit list. The court can order them to tell us what are the hot documents, where are the Brady issues. It's not enough just to give it to us in this volume of discovery. We need it identified, especially given the short time. But our position is that the court should strike the death penalty in this case. It will take the heightened level of pressure down, and it will allow us to focus on the trial phase only rather than the mitigation phase as well. There is precedent in Idaho. The court knows.
Circumstances were completely different, though, counsel.
I'm not saying our circumstances are identical, but it's a due process issue, just like was analyzed in the Vallow case. That was analyzed as a due process issue because counsel didn't have the opportunity to be prepared. And that was grounded in other case law. That was Riviera versus Clemente, Grover versus Florida, and Lopez versus Matthews. And those apply now. We do not have an opportunity to meet the state's discovery, even though we've diligently been trying to do so. And this is the appropriate remedy. And we're asking the court to make the orders for the state's disclosures and to strike death.
Judge, in this case, the state has made every attempt to try to comply with Rule 16. 7 days after a defense counsel entered her notice of appearance, she indicated she wanted everything that we had. And we started the discovery process. This was continued routinely throughout this case. Generally, documents such as police reports, lab reports, et cetera, were bait stamped and then turned over, and essentially turned over in the same way that we received them, in the same order. As they were done and turned over by various investigating officers or whoever, we put a bait stamp on them. Photographs were done in the same fashion. Larger files, and I could say that, for example, most of the files that come from the FBI tend to be larger files that can contain a multitude of different things. Those were placed in an AV folder and discovered.
Were they meaningfully indexed?
I can tell you for FBI documents, the defense was provided essentially an index for all FBI documents because they requested everything that was on a shared drive for the FBI, and that was turned over with a searchable index.
Mention of a problem because of the password protection of documents.
Yes, and we addressed that. Actually, we first heard of that in, I believe, April of 2023. And Mr. Thompson wrote a letter to Ms. Taylor saying that he understood that some of the PDFs were locked, but advised counsel they could get around password protection by hitting print to PDF and then saving, and that allowed those documents to be searchable. They were advised of this over 2 years ago. It's true there's a large amount of discovery. There was a 6-week-long investigation prior to a substantiated tip that led to Mr. Kohberger's arrest. So yes, there was a massive amount of discovery. We extracted cell phones for anyone that had any kind of connection to the victims. We gathered surveillance video for weeks, if not months, of random places throughout Moscow trying to figure out what happened. So to answer your question, there's a ton of discovery, and the majority of it is completely irrelevant.
Are you aware of any Brady information that is in the the cameras that are not the ones listed in your route of travel? And
No, Your Honor, I am not aware of any Brady material, any exculpatory material that's within those videos. The defense is right. All discovery was routed through MPD. We have a central location for collecting all the evidence, all the information, and then it was sent to our office. And then it was primarily reviewed by myself and Mr. Thompson, given approval, and then immediately sent over to defense. Files were kept in the same way by our office as we've discovered. That's how they've been maintained. And the parties are just on equal footing in this regard. Defendant's motion is just replete with these mischaracterizations and just completely false assumptions. For example, they say that there's so many investigators involved on this case. While that might be true that there were many investigators involved on the investigation, those investigators don't help us in the administrative task of organizing and sending out discovery. Further, we do have a PBK case management system, but it is not at all the way that it is described in the defendant's motion. For example, we don't have this global search function. We don't have the ability to just generate reports based off of witnesses. Agencies can't just directly upload into our system. We just don't have that capability. The reality is we rely on a self-created spreadsheet. Throughout the case, defendant has filed over 20 separate requests for discovery. There's been 400 itemized requests for different items, and the state hasn't just simply responded with whether or not we complied. We directed them specifically to where they could find that specific item, if it existed, the location, the description, and the date that it was discovered. I would just go back to that massive dump that we were talking about of the 50 terabytes of data. Defense has had that for over 2 years. It's hard to, I guess, rebut a lot of the allegations because there's no specifics. They just talk in these general terms about all of this data, and I'm not totally sure how to respond other than we've given over the data as we've received it. And they've had the majority of it for several years. Most importantly, defendant has not specifically pointed to any particular piece of evidence that has been withheld or any actual prejudice suffered, and instead just points to the vast amount of discovery, which we have absolutely no control over. The state has in good faith complied with our discovery obligations, and there's just simply no basis for a sanction. And so we had asked this court to deny their motion. Thank you.
This motion is not about withheld discovery. This motion is about discovery in the format it's in, the vast amount of it, and what's happened over the last few months that have taken us off track and our inability to be prepared. And that remains true. The 50 terabyte server that we received sometime in April of 2023 is the one that contains the U of I footage, and it contains a lot of footage around the town. We have been able to go through most of the footage other than the U of I. When the court asked the prosecutor,
Counsel, is there any known Brady material in the U of I surveillance cameras?
Not to the state's knowledge.
Your Honor, I think you'd have to watch that at various relevant times to know if there is or not. I think when you're thinking about Brady material, when we're thinking about video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify, there very likely are vehicles, light and color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. We've watched a lot of the video that's contained on that server. Also on that server are vast amounts of bank records, vast amounts of cell phone for all of the people that Ms. Jennings mentioned, the deceased and people close to them and other people.
They've indicated that their experts have examined that and found no connection between Mr. Kohberger and the decedents.
I'm grateful to have recently learned that. I mean, that's what we believed, but that was in that March disclosure when they said that they'd examined those, and those were computers, the 7 computers, I believe. It's that kind of thing that takes a lot of time. In addition to that server, there's all of the other information that comes in different ways. I'll give you an example of the delay. We received a lab report that was dated March 30th. The state received it March 30th, and this wasn't this year. This was obviously not this year. It wasn't even last year. We didn't receive it until May 8th. So the delay going from Moscow Police Department getting it, the prosecutor getting it, to getting it into our hands, that's well over a month. That's a long time for delay for the routing process. I think it's important to realize that the FBI index we have, you can't push a link and get to the document, but I do at least have that index. When we're talking about locked documents, the print to PDF, that's the problem. That's the steps, the additional steps that it takes when we're talking about thousands upon thousands of pages of documents. I think it's hard to imagine that there's not material somewhere in there that isn't favorable to the defense in some way. We recently found that, and we found a pretty good lead that we're trying to follow up on, and that is really what it comes down to. This is not organized data. It's not easy to go through. We've made substantial steps. The due process requires that something be done, and striking the death penalty is the thing that must be done.
All right, well, I will take, it'll help to review file. Number one. Number two, with respect to the witness, with the exhibit list. Now, I will say the exhibit lists need to be specific and detailed, not Exhibit 3 video, not Exhibit 3 video from X Bank. It's Exhibit 3 video from X Bank, minutes 25 through 27. Detailed, specific. I would also look at as a issue whether it might be appropriate to require the state to certify that it is unaware of any exculpatory material that it views as exculpatory, that it would, for example, feel it would have the obligation to bring forward if the defense were unaware of it, that has not been identified by the defense throughout the motion practice and discovery and their exhibits and witnesses, et cetera. But I will look at the issue and issue a written opinion on the matter, because I think obviously at a minimum for appellate purposes, you'll want that. So with that, I don't believe we have any other motions to take up today. Did I miss any?
Your Honor, we wanted to approach the court in regard to the review of the jury questionnaire and whether that can be conducted remotely, and when the court would like to do that.
Yeah, so I haven't had a chance to look through your responses to my proposed jury questionnaire. I will do that. Keep that just as a tentative. We can do it by Zoom or WebEx or something like that remotely. There's no need to travel down here to do that. And it may be that I simply just need more time and will tell you, let's take it up at the pretrial conference. I think we'll have time if we get it done at that time. So
Thank you, sir.
I didn't anticipate that I would actually get to the point where I would have given you my draft of what
I think it ought to look like by this deadline. So that's part of the reason I had calendared it, so.
And I can tell you, we very much appreciate that the court was able to provide us with your draft, because I think that simplified the issues, and as you review them, there are just a handful of things that are potentially in dispute.
Anything else from defense?
Your Honor, with regards to the exhibits, because they're now scheduled to be due the same day, we'd actually like to see if we could have an additional week.
I will give you additional 1 week after the state's exhibits are due.
Thank you.
All right, I think with that, we are adjourned. Thank you.
Okay over there? Is your victim at the hospital? Someone shot there. Alright, the ET doesn't take pictures of the, is it domestic related? With the daughter, Stand by.